Good evening, and welcome to the finals of the 21st Wabash College Moot Court competition. My name's Todd McDormand, and I'm a professor of rhetoric and associate dean here at the college, and I help administer the program. We had another invigorating competition this year featuring 30 students in the preliminary rounds. As usual, the judges, composed of alumni and faculty, were impressed with the preparation and skill of the student advocates in undertaking this voluntary but very demanding co-curricular activity. I'm not sure this is working. Now, from the 30 preliminary participants, 12 advanced to the semifinals, which were held last night. And before you, you have the final 4 competitors who will compete for the honor of top advocate this evening. Before introducing the advocates, I would like to welcome our guests from Lawrence North High School, who are part of a law and government class. These high school students are engaged in arguing this same moot court problem in their class. I also want to thank all of the students, alumni, staff, and faculty who were involved in this year's competition. That includes the participants, judges, and alumni who assisted in arranging and supporting the event. I'd particularly like to acknowledge Scott Himsel, Matt Griffith, John Pachter, and Rick Pitts for their many years of dedicated service to our moot court competition. I'd also like to note the contributions of staff like Eileen Bowen, Adam Bowen, Philip Marriott, Campus Services, Bon Appetit, Communications and Marketing, and Alumni Affairs. Without the help of all of these staff people, we could not put on this competition on an annual basis. I will now introduce the finalists, and after that, Professor Himsel will introduce the final round judges. Following that, the participants will deliver their oral arguments, the judges will confer about the outcome, announce a decision, and then we have a reception in Littell Lobby. Tonight, representing the petitioners, that's Arnold Gandil, and advocating on behalf of a subjective intent standard for evaluating threatening speech, are Matthew Bender and Andrew Dettmer. Matthew Bender is a junior from Hobart, Indiana. Matthew is a classics major and a history minor. He is a member of Kappa Sigma, and his activities include the Classics Honorary and the Glee Club. After Wabash, Matthew intends to pursue graduate studies in classics. Tonight, Matthew will be making the statutory interpretation argument for the petitioners. Congratulations to Matthew. Joining Matthew is Andrew Dettmer, a senior from Auburn, Indiana. Andrew is a political science major and a double minor in rhetoric and history. He is a member of Phi Gamma Delta, and his campus responsibilities include Sons of Wabash, being the corresponding secretary for Phi Gamma Delta, and serving as president of the Pre-Law Society. He plans to attend law school after graduation and focus on litigation. Tonight, Andrew will be making the constitutional argument for the petitioners. Please congratulate Andrew. Representing the respondents, that is the United States of America, and arguing to affirm Gandil's conviction are Jacob Burnett and Daniel Thompson. Jacob Burnett is a senior from Mishawaka, Indiana, who resides in Cole Hall. Jacob is a political science major and a double minor in rhetoric and psychology. Among Jacob's campus activities, he is a member of the Student Senate, Sons of Wabash, the Pre-Law Society, and serves as a research assistant for the Political Science Department. After graduation, Jacob plans to devote himself to improving the public good. Tonight, Jacob is making the statutory argument for the state. Congratulations to Jacob. Finally, we have Daniel Thompson. He's a sophomore from Jeffersonville, Indiana. Daniel is a political science major and a French minor, a member of Beta Theta Pi. Daniel is involved in College Mentors for Kids, the Pre-Law Society, and The Bachelor. His most passionate interests include music and working with children. After Wabash, he is interested in Teach for America and law school. Tonight, Daniel will be making the constitutional argument for the state. Congratulations to Daniel.
It's my pleasure to introduce our panel of distinguished judges. Our Chief Justice this evening is the Honorable Jane Magnus-Stinson. a federal judge who serves on the United States District Court for the Southern District of Indiana. She's had a long and distinguished legal career that has included civil litigation, counsel and deputy chief of staff to Indiana Governor Evan Bayh, long service as a state court judge, and work as a federal magistrate before becoming a federal judge. Judge Magnus-Stinson's roots are in the liberal arts as a French major at Butler University and a member of Kappa Kappa Gamma sorority. She attended IU McKinney School of Law. We are thrilled to have her lead us this evening, not just because of her work experience, but her long service as a teacher of advocacy. Welcome, Judge. Our next panelist is Andrew Klein, Dean of the IU McKinney School of Law in Indianapolis. Dean Klein earned his undergraduate degree at the University of Wisconsin and his law degree at Emory, where he had the high honor of being editor-in-chief of the Law Review. After practicing with the prestigious Sidley & Austin firm in Chicago, Dean Klein entered the field of law school teaching, where he has become an expert in tort and environmental law. IU McKinney is an important partner in education with Wabash, and we are very happy indeed to have Dean Klein with us tonight. By tradition, our third seat is occupied by a Wabash graduate currently serving as a judge. Tonight, we have Judge James Joven, who serves on the Marion Superior Court in Indianapolis. A member of Beta Theta Pi fraternity and a history major, Judge Joven graduated from Wabash in 1988 and the IU Maurer School of Law in Bloomington. Judge Joven has been very involved in public service, including as an Assistant Attorney General for our state and as Indiana Securities Commissioner. Judge Joven, welcome home to Wabash, and thanks for your service tonight.
Thank you.
And finally, and also by tradition, our panel includes a Wabash faculty member. This year we have the Dean of the College, Scott Feller. Dean Feller received his undergraduate degree at Willamette University in Oregon, his PhD at the University of California. Dean Feller models what it means to be a very successful faculty member as winner of the college's Teaching Award, a frequent author of significant scholarship in chemistry, and a teacher who frequently engages his students in his research. Dean Feller, thank you for accepting our invitation to judge tonight.
Thank you. This matter is before the court in the case of Arnold Gandil, petitioner versus the United States of America, respondent. Is the petitioner ready to proceed?
Yes, Your Honor.
You may begin.
Good evening, Your Honors, and may it please the court. My name is Matthew Binder, and I represent the petitioner, Mr. Gandil, in this appeal. Today, I will be arguing that the trial judge, to the harm of our client, misinstructed the jury when they were told to apply only an objective intent test to see if Mr. Gandil's comments were threats under 18 United States Code 875C, which states that transmitting in interstate or foreign commerce any communication containing any threat to kidnap any person or any threat to injure the person of another is a federal crime punishable by up to 5 years in prison. Several of the reasons we believe that this statute was misapplied in this case are that threats are not defined by the statute itself. Mens rea requirements, per the Staples and U.S. Gypsum court cases, are the rule and not the exception in statutory interpretation, and that an objective intent standard being applied to the statute will punish simple negligence, chilling speech, and punishing people for simple misunderstandings in the realm of pure speech, which is a realm that this country has traditionally experienced a lot of freedom and from government regulation in.
Excuse me, counsel.
Yes, Your Honor.
The statute, what are the words in the statute that set forth the mens rea for the crime?
Well, Your Honor, the statute doesn't define the word threat. And so the word threat needs to be taken by its plain meaning according to the Sandifer case, And so the plain meaning of threat.
Excuse me, but threat is the action. Where is the mental state, the words that express the required mental state for culpability in the statute?
Your Honor, threat by itself in the plain meaning of the word implies intent. In Blackstone's Law Dictionary, in Webster's Dictionary, it's defined as intent to harm. It's a statement that conveys an intent to harm, a subjective intent. There's no common understanding of the word threat that does not include subjective intent. The earliest cases dealing with 875C actually agreed with that conclusion that there should be a subjective intent standard. And we can see this in our everyday lives when someone makes a comment that someone thinks means they intend to do them harm. They say, "Are you threatening me? Is that a threat?" Implying that they're trying to find out if there is intent there. And
but counsel, you would agree with me that there is not language that states knowingly, intentionally, with malice aforethought. There's nothing like that in the statute. Would you agree?
Correct, Your Honor. That's not explicitly stated.
And let me follow up with that. In a traffic case, for example, speeding. If a motorist is traveling more than the posted speed limit, it's a violation of law, correct?
Correct, Your Honor. And
so there's no knowing there, there's no intentionally. I didn't know I was going over 55 miles per hour. I didn't mean to go over 55 miles per hour. Still a violation, isn't it?
Your Honor, I believe that that's a different type of case due to the severity of the sanctions. So a speeding violation doesn't get the same amount of punishment as in this case, where the person is being punished by up to 5 years in jail, and our client was actually sentenced to 44 months in prison.
Counsel, didn't the Court of Appeals actually impose a mens rea requirement when it indicated that the second element that the government must prove is that the defendant transmitted the communication knowingly? Isn't knowingly the mens rea, and doesn't the mens rea apply to the communication here?
Your Honor, I will concede that there is a mens rea element in the statute, but we believe that there should also be a mens rea element with regard to subjective intent, because Congress did not define the word threat, and therefore it needs to be interpreted in its plain meaning, and because free speech is an issue that the First Amendment has long protected, and people in this country go about their lives with a high expectation that their speech will not be regulated by the government, we need to have a standard that ensures that when the law is vague, as it is here, that people will be protected from misunderstandings and misconstructions.
But surely the law needs to be clear as well. And so if you impose a subjective standard into your definition of intent, how would one make that determination absent simply asking the individual?
How would someone, so your question, Your Honor, is basically how would we obtain convictions under a subjective intent standard? Well, Your Honor, we do that quite often. There are, so for instance, in a premeditated murder case, how do we prove somebody premeditated the crime? We can present circumstantial evidence absent a confession. If, say, the suspect takes the fifth and won't confess, well, then you can present circumstantial evidence. You can go online and look at this person's Google history and see whether this person was really intending to carry out this crime. But that's, again, a matter that was not presented before the jury in this case. They weren't told to search for subjective intent. They were told to search for objective intent, what a person would perceive.
Okay, but what's your authority for the requirement of subjective intent in this case? Why would we, the Congress wrote the law, why would we read something into the law that the Congress didn't write into it?
Well, Your Honor, Congress also didn't write the objective intent into the law. And so if we need to fall back on a default when Congress is vague, as it was in writing the statute, we need to fall back on the plain meaning of the word threat. And we also need to consider the fact that the First Amendment is in favor of the person making the statement, that the First Amendment is designed to protect the free speech at issue. And therefore, subjective intent achieves that goal, and subjective intent is what should be written into the statute.
But counsel, I'm still confused. When we're talking about the threat, that's the act. That's the actus reus. That is the thing that the defendant did that subjects him to criminal liability. But why are we talking about the mental state when we talk about the act, in defining the mental state with the act?
Well, Your Honor, as I said before, mens rea is the is the rule rather than the exception. And so if mens rea, as far as intent is not in the statute, then we need to fall back. If it's not defined whether there should be mens rea or whether there shouldn't be mens rea, we need to fall back and apply mens rea to protect from misunderstandings.
Absolutely, and isn't the default position when the statute does not state a specific intent, then it is general intent, knowing, intention?
Well, Your Honor, I think especially in a case like this of peer speech, Justice Marshall in his concurrence in the Rogers case said that we have to be especially wary of applying reasonableness standards in cases of peer speech, which is what this is. My client simply posted statements, worded statements on his Facebook post, and so there needs to be more protection there with regard to subjective intent.
What does the United States versus Cosma case say regarding the question of specific intent?
Your Honor, that case was in reference to, I believe it was Statute 871, which had to do with threats against the life of the President of the United States. And we believe that the facts of that case really separate it from what's going on here. A public figure, there's not going to be a public panic based on the statements that my client said. And so we really believe that it would be more legitimate for a court to apply an objective test in a case like that.
Why would you take that policy position if the President has the Secret Service and all sorts of other people to protect him? Why wouldn't we create the inverse policy argument, which would be, for example, for his wife who has no such armed services force to protect her, that we would employ the same relaxed standard?
So, well,
you're saying it's the President, so it can be more relaxed. I'm saying we have an individual here who we're trying to prevent from being intimidated or threatened or placed in fear. So why wouldn't we apply that more relaxed standard there?
Well, Your Honor, I think, again, it just goes back to the fact that my client needs to be protected from simple misunderstandings in a case like this, when there are so often angry people who get divorced and then have a lot of angry feelings about it. And so that my client needs to be protected from the fact that he could choose his words poorly and his ex-wife could assume that he's making a threat toward him.
Well, certainly your position would protect your client, but how can we read the statute to protect the person who feels threatened?
Well, Your Honor, really in speech cases, the protection mostly falls on the person who was making the statement. Somebody can be protected from threats, true threats, the word true threats is their intent. Somebody can be protected from someone who really is making statements where they're saying they intend to do them violence.
And didn't the trial court then attempt to fix any issue with the statute by limiting the threats to true threats as defined by the Supreme Court?
Well, Your Honor, actually it said threats, and the Supreme Court in the Virginia v. Black case actually said that true threats are statements that convey, when somebody means to make a statement that conveys an expression of intent to do someone harm. And so threats, like I said earlier, Your Honors, is really a word that has no common meaning outside of subjective intent. And it really also has to protect people from having their speech chilled when they may just choose to say nothing rather than risk saying something that could be misinterpreted. So for instance, I think the Fulmer case is a great example of this, where there was an informant in a bank fraud case who called an FBI agent and said the silver bullets are coming. And what he meant by that was that a solution to the problem is at hand, and that was his reference. The FBI agent didn't understand that reference, and he took it as a threat. And the person was convicted under the objective intent standard, even though he didn't actually mean to cause anyone harm. And there were two defendants, or there were two, excuse me, Your Honors, there were two witnesses at the trial who testified that he had not meant any harm to the FBI agent and had tried to explain that it was all confusion. And so we really believe that this person in the Fulmer case would have been protected by a subjective intent standard, and other people who may be worried that their statements will be censored based on what a prosecutor would like to bring to court.
Couldn't someone always use this argument that they didn't intend to make the threat, that this was not their intent right up until they did someone harm?
Well, yes, Your Honor, but I think that goes back to my point about a crime like premeditated murder. Of course, they could say that they didn't intend to do someone harm, but a jury, when instructed to look for subjective intent, could look at all sorts of circumstantial evidence, and there could be an investigation to see whether that person actually intended to make that statement. It's just a matter, Your Honor, of what a jury should be looking at in this case.
Do you have a quarrel with how the trial court defined true threat in this case? And if so, what is it?
Yes, Your Honor. They said that a statement is a true threat when a defendant intentionally makes a statement in a context or under such circumstances wherein a reasonable person would foresee that the statement would be interpreted by those to whom the maker communicates the statement as a serious expression of an intention to inflict bodily harm or take the life of an individual. Yes, Your Honor.
I'm sorry, I didn't mean to conclude your answer.
Yes, so anyway, Your Honor, so they read, the trial judge in the court told the jury that it was based on objective intent, what a reasonable person would assume, which is not what is written in the statute. The statute is vague on what a threat is, and so a trial judge shouldn't be able to read into it an objective intent when the common meaning of the word threat always implies subjective intent. And so, Your Honors...
Is that how the United States Supreme Court defines true threat, always requiring subjective intent?
I see that my time has elapsed, Your Honor. May I answer your question?
Yes.
So your question is, how has the U.S. Supreme Court always defined true threat? Well, again, Your Honor, I would go back to Virginia v. Black, where the court said that a true threat is when somebody means to make a communication that expresses an intent to do someone harm. And so even the Supreme Court has considered that a threat generally means subjective intent. And for all of the reasons listed above, we respectfully request that this court reverse the lower court's opinion. Thank you, Your Honor.
Thank you. Mr. Dettmer.
Your Honors, I will be handling the rebuttal and request 2 minutes to handle that.
You may.
May it please the Court, my name is Andrew Dettmer, and I represent the petitioner, Mr. Gandil. In this case, I will be addressing the question that the First Amendment does indeed require a subjective intent standard to be applied in cases of speech such as this, and this is for 2 reasons. One, time and time again, when the government fails to use a subjective intent standard, innocent people are wrongfully incarcerated. And secondly, that what the First Amendment requires is concurrent with what the common interpretation of what a threat actually is.
The First Amendment is not an absolute protection of free speech. Is that correct, counsel?
Correct, Your Honor. In cases, there are very narrowly ruled cases.
So the classic statement is that one cannot cry fire in a crowded theater to protect society from having speech cause harm to others.
Correct, Your Honor.
Why isn't making a statement that causes someone true fear the equivalent of crying fire in a crowded theater?
Well, Your Honor, I would like to take you to the Supreme Court case of NAACP versus Claiborne Hardware, where we had a case where Mr. Evers, a NAACP officer, in a crowd in public, said a statement that if we catch any of you going in any of them racist stores, we're going to break your damn neck. Later saying, sheriff could not sleep with any boycott violators at night, implying that even the police could not keep you safe. And yet, when that case was brought before the Supreme Court stated that Mr. Evers' speech did not exceed the bounds of protected speech because his advocacy was not directed towards inciting or producing an imminent lawless action. And so in the case of your fire example, yelling fire in a crowded movie theater is going to cause people to flee. Someone could get hurt in the scuttle to get out of a theater they think is on fire, because it's falsely yelling fire in the crowded movie theater, not yelling fire when it actually exists or when you think that there's a fire that someone has a need to fear. And so it's the intention to cause people to falsely flee that makes it illegal to yell that fire, not just yelling the word fire. And a similar case where I would direct you to, which is U.S. v. Fulmer, where we have an incident, as my co-counsel alluded to earlier, where an informant says, silver bullets are coming. Now, that agent testified that he found those words, quote, chilling, and, quote, scary. Yet the informant in that case and 2 witnesses said that they were using it to basically convey that, quote, clear-cut evidence was coming. Now, that is a case where an objective standard was used, and this person was thrown in jail over a poor wording choice, not actually an intent to threaten the agent. And that is the scary part, if we use an objective standard, is that simple negligence can become malice.
But counsel, in the Fulmer case, was the conviction upheld?
I believe it was, Your Honor.
And so the argument about, well, silver bullets meant something innocuous rather than silver bullets meant I'm threatening to shoot the agent, that kind of washed out in front of the trier of fact, didn't it?
I believe it, I mean, yes, Your Honor, clearly it did, but the problem with that is we can see that going forward, this can cause a chilling effect on speech. And as Justice Brandeis said in Whitney versus California, fear of serious injury alone cannot justify suppression of free speech and assembly. The default standard when it comes to speech is that it's not regulated, that you are free to say it. It's one of the enshrined freedoms that we have.
Except when you have threats.
Well, Your Honor, if you look at Virginia versus Black, the definition of a true threat so true threat encompasses those statements. So we know there's a communication. We know that a communication is happening at this point by the definition. Where the speaker means to communicate. So a statement where the speaker means for a message to be sent of a serious intent, a serious expression of an intent to commit an act of unlawful violence. So it's not simply that a threat of, oh, you interpret it as a threat, so therefore it becomes a threat. The speaker actually has to mean it.
Am I correct, though, counsel, that most circuits that have considered this issue do not agree with your reading of the Supreme Court's decision in Black? Isn't it correct that most circuit courts considering this question do not require a subjective intent?
Yes, Your Honor, except the Ninth Circuit did take issue with this interpretation, and I think we have to be careful because we can see a way that in this very case we see an example where a quote-unquote reasonable person wrongfully interpreted something, and I would direct you to the parody of the Whitest Kid You Know sketch, because this parody does four things in successive order. First, it criticizes the law, saying that, did you know it's illegal to kill my wife? He's clearly criticizing the law in that statement. That is very much a parody criticizing the law. Secondly, it's parodying a comedy, so it's a parody of a parody itself. It's a parody of satire. He is not, threatening. Secondly, there's a link at the bottom, linking directly to the comedy routine. So if someone did interpret it as a threat, you could see that he's linking directly to the source. And then finally, he concludes with the statement, art is about pushing limits. I'm willing to go to jail for my constitutional rights. Are you? Yet, in the original case, an FBI agent testifying stated that they did not click on the link, yet this agent was supposed to help establish that a reasonable person could interpret as a threat. And the problem here is that a reasonably objective person is not the best standard to use in this case, because freedom of speech is supposed to be protected unless we are going to narrowly tailor the law and the thing we are ruling upon so that we do not violate someone's freedom of speech.
But isn't the reasonable person actually the jury? Not just the one individual to whom the language is directed, but at trial, the trier of fact, typically the jury, jury of 12 peers is going to hear those words and make that decision for itself. And it has to come to a unanimous decision.
Correct, Your Honor. And while that might be the case that the jury is the final arbiter as the reasonable person, the problem is that we can't instruct them simply what a reasonable person is, because there's a difference between finding a standard of objective intent that you could interpret as a threat rather than a subjective intent that the person meant it as a threat. Because as I stated earlier, this can cause negligence to become malice. Someone, by per word choice, could end up in jail because they worded something in a way that someone interpreted as a threat when they never meant it to be a threat. And in order for free speech to flourish, it has to have a very, very loose set of limits, because if people are worried that their speech is going to be considered a threat when someone else is, such as Eminem, who says very similar things, so does Bob Dylan. Many singers have said similar things to what Mr. Gandil said. But they are protected because it's art, and we should not be preferencing a form of speech and making someone consider whether or not their speech is going to be construed as unconstitutional.
Do you consider the types of statements made in this case to be a form of art, counsel?
Your Honor, it's not up to us to decide the artistic merit of his word choice. It's simply to ensure that someone who wants to express art does not fear them containing. And if we are going to say what Eminem puts in his lyrics about wanting to kill his ex-wife because of a child custody case, then how can we say that someone who also writes in a lyrical form does not have the same right to say those statements?
But isn't that where the jury comes in? The jury, as the reasonable person, gets to make that determination. And these 12 people will know what a threat looks like. It's like Justice Potter Stewart said about obscenity. I know it when I see it. These jurors, threats, I know it when I see it. And they have to come to a unanimous decision, don't they?
Correct, Your Honor, but the difference is that if you instruct a jury to find an objective standard of intent so that just the reasonable person from the outside has to see it versus a subjective standard of intent, they're going to be looking for different things. And if they are only looking at how someone can interpret the threat, then we are going to be very close to curtailing future speech that we don't want to curtail.
But isn't the reasonable person taking into account those circumstances that you would have considered under the subjective test?
I do not think so, Your Honor, because if a subjective test is used, you're going to have to look at how does the person who's saying these statements mean it. And in the case, like I stated earlier, Fulmer, an objective standard found someone who used a common expression that was misinterpreted by one person as sufficient evidence to convict that person.
But Fulmer was upheld. Fulmer, there was a conviction. You're arguing facts that are not in support of the decision that was ultimately reached. So I discount Fulmer altogether.
Well, Your Honor, in that case, then I would take you to Claiborne, which, as I said, very similar statements are stated by Mr. Evers, yet he was found not guilty, and in that case, action was even taken against the people that he threatened. Lists of their name were put in public places. Violent action was even taken against these people, yet he was not convicted because he did not incite imminent lawless action.
But since that time, I'm sorry.
Go ahead.
Since that time, this court has spoken on the issue of restrictions on speech, particularly in the Black case we've been talking about. And this court held that the First Amendment permits restrictions upon the content of speech in a few limited areas, which are of such slight social value as a step to the truth, that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. Why do you think your client's statements fall outside that limited area? What's the value? I guess I could ask it another way. What's the value of your client's statements?
Your Honor, I'm not here to argue whether or not what my client stated was not objectionable or not, something that many people would find issue with. But the issue here is that, like I stated, if we have a case where a starting musician, someone who doesn't have a lot of, writes an album right after a breakup or right after his wife leaves him and says very similar things, they might worry. They might not say what they wanted to say. In this case, passion for an issue can put them dangerously close to falling under the subjective standard, depending on the strength of the language they use to argue this case. And so it's not so much that we are protecting what Mr. Gandil is saying, but we are protecting people from the ability to say things that they might worry come too close to Mr. Gandil's statement. And when we're dealing with a First Amendment case, we cannot allow for a law that will silence speech, because as Justice Learned Hand said in Masses Publishing Company versus Patton, if there be time to expose through discussion the falsehood and fallacies, to avert the evil through education, the remedy to be applied is more speech, not enforced silence. And in this case, we would be enforcing silence. I see my time is up. May I have a moment to conclude? Yeah. So in this case, we will have a chilling effect if speech is to be censored in this way, and that we have seen time and time again where an objective standard has failed the public. And with that, we respectfully request that the court reverse the lower court's decision. Thank you.
Thank you. Counsel for the government, Mr. Burnett.
May it please the court. My name is Jacob Burnett, and my co-counsel and I represent the United States of America, the respondents in this case. Today, as a matter of statutory interpretation, the conviction of threatening another person under 18 U.S. Section 875C does not require proof of the defendant's subjective intent to threaten. This is for many reasons. However, the two most important and the most pressing is when we look at the reasons for which Congress implemented the statute in the first place. They implemented the statute as a means by which to prevent the harmful effects that flow from true threats. Secondly, these narrow definitions of speech that can be regulated extends to true threats, which both the jury was informed of when analyzing whether or not Mr. Gandil violated the statute.
Counsel, go ahead.
Is it your contention that the trial court accurately defined true threat in the jury instruction it gave?
Yes, it is, Your Honor. Because of the fact that when we look at the statute, the idea of a threat is objectively defined by Congress's direct intent to leave out a subjective requirement.
Where do you see that in the statute?
Your Honor, we see that in previous statutes. When Congress based this statute off of previous attempts to regulate threats, they, over congressional hearings and congressional intent, they decided that a subjective intent was not required, and they adopted. Go ahead. No, you go ahead, Your Honor.
If Congress meant to do what you suggest, why didn't Congress write that into the statute?
Right, what, Your Honor?
A definition in the way that you suggest.
Well, Your Honor, the definition of threat was adopted in the wake of how individuals interpret true threats. And because they left out the subjective intent, but left the idea of subjective intent and other requirements when analyzing threats, a very reasonable and rational interpretation of that is if Congress wanted there to be a subjective intent requirement, they very well would have put it there. So when we analyze the idea of what a threat is, they are not common misunderstandings as the petitioners have put forth. And this is very present when analyzing the Facebook post that he put, such as, excuse my language, hurry up and die, bitch, so I can bust this nut all over your corpse from atop your shallow grave. I used to be a nice guy, but then you became a slut. Guess it's not your fault you liked your daddy raped you. So hurry up, die, bitch, so I can forgive you. And these, Your Honors, are not common misunderstandings. And under an objective intent in which Congress adopted for the statute to be read as, we have adopted the purpose for the statute, to prevent the fear that threats engender.
But counsel, let's go back to the definition of threat.
Yes, Your Honor.
You say that the reasonable person is left to determine what a threat is for purposes of this statute. And that's by case law, and that's fine. But why should this court allow the reasonable person to make this decision? Given that, as I stated with your opposing counsel, there is a jury of the defendant's peers who will make that determination. But across the country, when this statute is enforced, doesn't that leave us with the possibility that it won't be enforced evenly?
No, it doesn't, Your Honor. The idea of the reasonable third party is a screening mechanism to ensure that 12 individuals must come to a unanimous conclusion, as you posited earlier, that when we look at ideas of true threats, we have the fact finders are with so many tools to understand whether or not the threat uttered is a true threat.
My problem with that standard, though, is that if you go from community to community across the United States, maybe those standards, what people consider to be a threat, are going to be different.
Oh, that's very interesting, Your Honor. And I firmly believe that when we're dealing with true threats, the very narrow category which, which Congress and the Supreme Court have outlined, the communities in which what a threat is may differ. However, we err on the side of the reasonable interpretation of a threat because of the fear that it engenders. So maybe maybe one community's idea of what a threat is different from another community's idea of what a threat is. However, the likelihood that a similar statement with similar context, with similar interpretation and reactions, get two separate results is kind of the reality of how criminal law operates. It's very fair because there are 12 individuals who are given those tools.
But in the First Amendment context, isn't that the problem?
No, it's not, Your Honor, because when we think about the way that free speech works, there are few ways in which true threats, and again, I think that when we think about the difference between a threat and a true threat, the true threat standard, the objective, reasonable interpretation of that threat.
Okay, I have to stop you here because true threat is a term of art. And The Supreme Court defined it as encompassing those statements, and this is what they said, where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual. They say nothing about reasonable people. They say nothing about really, explicitly anyway, about subjective intent. So as much as you're critical of the petitioners for wanting to graft on subjective intent, you're grafting on this reasonable person standard that is not included in the Supreme Court's definition of true threat. So what's its genesis? Why should we never said that when we defined true threat. Why should we accept that as the appropriate standard here?
We accept that standard, Your Honor, because when Congress adopted the statute, the true threat standard that they decide to have was the objective standard. The idea of reason...
Whoa. True threat doesn't appear anywhere in the statute. Where's this coming from?
Your Honor, true threat is coming from the word threat itself that was interpreted as, because we talk about the fear of chilling speech. We don't read threat as simply threat. It's read as a true threat, and the instructions to the jury are the true threat requirements in order to prevent the chilling of speech. The reasonable person standard is adopted because adopting any other form of standard, such as a subjective standard, completely defeats the ultimate purpose of why the statute was adopted.
Counselor, I want to go back to something that Justice Joven raised earlier. Wouldn't your position read the mens rea completely out of the statute?
No, it doesn't, Your Honor, because of the fact that there is a mens rea of general intent. And because this is a mens rea of general intent, Mr. Galpin understood the meaning of the words in which he spoke, the context in which they were spoken, and the intention of speaking them. He sat down at a computer screen, wrote them out, and not only was that happening, he was made well aware of the fact that they were threatening his ex-wife when she received a protective order in which he continued to make fun of, on Facebook. And the 2 points regarding the Whitest Kids You Know sketch, that count was actually dropped. Galpin was only convicted on counts 2 through 5. The Whitest Kids You Know sketch was actually part of the first when he was indicted on the first part, and because of the screening process that we have, this is clear evidence that the jury of 12 people with the reasonable standard was able to delineate the idea of what a true threat is and what just a regular nonsensical threat would be.
Well, let's go back to just pure statutory interpretation. You agree that there is a general intent requirement in the statute, yes?
A mens rea general intent, yes.
Yes, and so general intent, knowing or intention, correct?
Yes, Your Honor.
And so why wouldn't the defendant have to know that the words that he is communicating is a threat?
Because, Your Honor, he himself cannot determine whether or not what he is saying is threatening, because it opens the door for he himself to always determine that what he is saying is not threatening. And the intent of the statute is that individuals on the receiving end will reasonably believe that they are in harm. And that's not only what Mrs. Galpin said, that is what the community where he threatened to shoot up a school happened to be, and that's what the jury adopting the reasonable objective standard decided to view the threat as.
Counsel, you just said something that raises an argument that your opponent discussed earlier. You said this would create an issue where the speaker himself would determine what is or is not threatening.
Yes, Your Honor.
Opposing counsel suggests that we can look to plenty of other evidence other than what's inside the individual's head to make that determination. Do you disagree with that?
No, Your Honor, and in fact, the jury was instructed to look at, to some extent, whether or not Mr. Galpin intended them to be threatening, and he took the stand and he said, I did not mean to say that these were threatening. And instead, the jury said, well, that's not accurate for the context, the fact-finding tools at which they were provided when reading the statute. And the statute was intended to be read as such because of the reason that it was adopted, to protect from the fear that it engenders. And when we come to the idea of the definition of a threat, the comments when they cite Webster's dictionary and things like that, we argue that that they're misinterpreting what a threat, the definition, because the threat, when they talk about means to the means to communicate, or the means to threaten, and the means and things like that, what the definitions actually imply are the means to follow through with your threat. And the constitutional safeguards in place with this definition of threat say that an individual does not necessarily have to believe that they will carry through with the threat. Not that Mr. Galpin was going to carry through with the school shooting. Instead, it's whether or not the threat that he uttered was reasonable to infer that the community that goes into the community schools that have to go into lockdown, the community, the fact that Mrs. Galpin now has to figure out how she's going to protect herself if her husband decides to shoot her. How are we supposed to prosecute threats under a subjective standard until the event has already occurred? And then it becomes too late, because the entire reason why this statutory interpretation is adopted from a reasonable perspective, and I know I keep saying it because it's the most important, is what Congress is trying to prevent. They're trying to prevent chaos. They're trying to prevent the premeditated murders from occurring. Because what the true threat idea that it's kind of coming from is that we want to prevent the premeditated murder. We want to prevent the murder. We want to prevent him going to the school and shooting up people. And if we adopt a subjective intent requirement, and the fact finders, have to heavily weight whether or not Mr. Galpin actually intended to shoot up a school to kill his wife, I think that we are letting
I think you're conflating two things. I don't think he has to intend to shoot up the school. He has to intend to threaten the shooting of the school. Right?
Yes,
Isn't that what they're arguing? They're not arguing that he has to mean it.
No, Your Honor.
They're arguing that he has to mean the threat. Not that he's going to do it. The Supreme Court made it very clear, but that he means to scare them, in essence, to threaten them.
But Your Honor, his interpretation of whether or not he means to scare them is not the problem. The problem is the fear that it causes. We want to prevent the school lockdown. We want to prevent his wife having to go through unnecessary means to ensure her safety. Because whether or not he intends to do, I see my time has ended. May I finish my statement and conclude?
Yes.
Okay, thank you, Your Honor. So the entire reason why we want to adopt this idea in regards to your question is that we want to make sure that that just because, Your Honor, I'm just, one second. That the intent of Mr. Galpin, regardless of whether or not he meant to threaten or not, still causes major disruption. And that is what the statute was aimed to do. And in conclusion, Your Honor, we respectfully request that you affirm the lower court's ruling, for not doing so completely opens a Pandora's box of true threats to terrorize our communities. Thank you.
Thank you. Thank you. Mr. Thompson.
May it please the court, my name is Daniel Thompson, and my co-counsel and I represent the United States of America, the respondent in this appeal. There are three reasons why 18 U.S.C. Section 875C is constitutional. The petitioner's threat is a true threat, as defined by Watts versus United States. Furthermore, the statute exists to prevent the threat from being enacted, to protect the fear of violence, and to protect the individuals from the disruption that fear engenders. Lastly, the objective test still accurately protects lawful speech. For these reasons, the ruling of the court should be upheld.
It may protect lawful speech, but it certainly chills protected speech as well, doesn't it?
Well, Your Honor, that's why we have an objective standard, is that way we can ensure that those that are participating in lawful speech can still be protected upon. We can use contextual factors, the language that the speaker uses to determine whether or not this is and should be protected by your First Amendment.
Now, the statute itself doesn't use the terminology true threat, does it?
No, Your Honor, but we have to confer to precedents to define threat. And as our opponents have done, they've used the dictionary definition. However, I think that it is more useful to instead use the definition of a true threat as defined by Watts versus United States, which is statements where a speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. And the language here is very important. We have to realize that the intention is to communicate the threat, not to allow the person to receive the threat as a serious expression.
Doesn't this court in Virginia versus Black say exactly the opposite?
The court case in Virginia versus Black does say the opposite, Your Honor. Or I'm sorry, can you rephrase the question?
Does Virginia versus Black support your position or not?
It does.
Can you explain?
Yes, Your Honor. So in Virginia versus Black, we have a case where, I'm sorry, Your Honor, I'm freezing up here a little bit. In Virginia versus Black, we have a case where,
Let me help you out, counsel.
Thank you, Your Honor.
Virginia versus Black. True threats encompass those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals.
Yes, Your Honor. That's the definition of the Watt versus United States that I have just said.
Right.
Yes.
Black
So,
quoted Watts.
yes, exactly. So this does support my claim that a true threat is when someone intends to communicate a serious expression of an intent to commit an act of unlawful violence to participate to particular individuals or group of individuals.
But going back to your co-counsel's argument, who makes that determination of what a true threat is?
The reasonable person. This is why we have a reasonable person standard, so that we're able to determine using contextual factors and the explicit language that the speaker uses to determine whether or not.
And then going back to my previous questions to your co-counsel, across the country, if we have a jury from each state, isn't the danger that those 50 different juries are going to come to a different conclusion on the same set of words?
Well, Your Honor, that's why we have to have jury instructions, so that way you're able to give them the contextual factors. And it's also assumed that we have.
Well, no, assuming that we have identical instructions. If we were to put forth an opinion that adopts your standard, the opinion would set out, well, here's an instruction that's acceptable. Every one of those juries would see the same instruction. But then we have the possibility of conflicting results.
Your Honor, I don't necessarily think that would happen, just simply because all 50 states do have access to Facebook, which is the interstate commerce that we're referring to here, and most people would be able to infer whether or not the statement was in fact a true threat or not. I don't think that there would be cultural references that would be absent at the knowledge of a particular set of jurors.
They'll know it when they see it.
Yes, Your Honor.
Where do you find the authority in Black for the reasonable person standard?
Where do I find the authority?
What language in Black leads you to believe that a reasonable person standard can save the constitutionality of the statute?
Well, Your Honor, in Virginia versus Black, we have U.S. versus U.S. versus White, U.S. versus Jeffries, U.S. versus Mabee, and U.S. versus Nicholas, all agreeing that the Black ruling does not require subjective intent to ensure society is protected. There's only one court, which is the Ninth Circuit, that concluded that it does not. So this is where we have our legal precedents, and as our opponents have mentioned, that this language is being misinterpreted. But like I just said, there's only one court that has come to this conclusion.
Right, but that's when we have splits in the circuit. That's why we have to make the decision on this court. So based on our precedent from this court, where can you find some authority for your position that the reasonable person standard can square with the carve out to the First Amendment that's contained in the Black case, the true threat exception to the First Amendment?
I'm not sure, Your Honor.
Okay.
So back to the Watts versus United States definition of a true threat. Gandil's threats are categorized as such, and his wife explicitly states that she did in fact take the threat seriously. She was fearing the lives of herself, of her child, and of her family. Furthermore, the speaker need not actually intend to act out the threat, which I think is the language that you were looking for earlier in Virginia versus Black.
But back to your former point, the target of the, I don't want to call them threats, but of the communication is the one who interpreted the words. Isn't the danger that someone's going to misinterpret what was being said, misconstrue it as a threat, a true threat, or some intent to harm?
Well, Your Honor,
isn't that what the problem is here?
Well, Your Honor, that's why we have to have the objective standard. So that way, neither party in the participated injustice can feel that their side should be considered more so. We have to have a rational, well thought out individual, 12 jurors, in order to decide what the proper punishment should be for this particular conviction. Furthermore, John Locke, in his second treatise on government, helps support this idea, and I think it helps better articulate the point in which I'm trying to make. In John Locke's second treatise on government, you enter a social contract in order to prevent two people.
Counsel, is that authority that we must rely upon?
No, Your Honor. The only reason I refer to this is to help articulate my point. And so when we have two individuals engaging with each other, we have to be able to have a third person that's calm, rational, that hasn't been inflicted upon any injustice, to be able to determine what the punishment ought to be. Furthermore, Mr. Gandil was not convinced or convicted on all 5 counts. And this, in fact, does show that a jury is capable to distinguish between a threat and a non-threat. The first count was thrown out because the jury was reasonable and was able to determine the context and in this particular count, it was the whitest kids you know quotation, so they realized that this is a quote, this isn't necessarily a true threat, so they're able to...
I thought that count was dismissed.
Yes, Your Honor, that's my point, is that this first count was dismissed. The jury is able to distinguish between what a true threat and a true threat is not.
So isn't it this reasonable person standard, though, doesn't this leave the possibility of denying the free speech rights of this individual? It seems that hundreds of people saw his posting on Facebook and didn't consider it a true threat, and yet this jury finds differently. How will we have consistency using your definition?
Well, Your Honor, the general offense requirements, firstly, is that the defendant transmitted a communication interstate or foreign commerce. And secondly, the defendant transmitted that communication knowingly. Thirdly, the communication would be construed by a reasonable person as a serious expression of an intent to inflict bodily harm or death. And so I think that answers your question. How can we objectively decide whether or not this is a true threat or not?
But all those Facebook users who even liked the defendant's Facebook page didn't seem to think that it was a threat.
Well, Your Honor, those 300 Facebook friends didn't necessarily have the contextual evidence that was provided in the trial court, and they were also his friends. So how do we know that they weren't taking his side on this particular issue and didn't report it just simply because they agreed with him? So my second point was that the statute exists to prevent the threat from being enacted, to protect the fear of violence, and to protect individuals from the disruption that fears engenders. So when we consider why this statute exists in the first place, we realize that we have to have this standard, this objective standard, in order to further prevent this threat from actually occurring. We can't sit around and wait until someone is murdered because someone's already said this and then say, oh, sorry, we knew this was coming, but there's nothing that we could do about it.
But the subjective standard could very well prevent that harm, couldn't it?
Well, Your Honor, a subjective standard, it's really easy for the accused to just come up to the stand and said, oh, sorry, I actually did not mean to say these statements, and then he would be...
The Claiborne hardware case.
I'm sorry?
Well, I'm not sure if that's the right case. The Silver Bullets case.
Yes, exactly. So in the Silver Bullets case, well, first off, let me clarify that this was a different statute under which this person was convicted. But we have a case where an FBI agent received a message saying the silver bullets are coming, but the FBI agent did not know what silver bullets were, so he believed that...
Well, he did know what they were, and he took it as a threat.
Yeah, exactly, but it wasn't meant to be as interpreted as such.
According to that defendant who was convicted.
I'm sorry?
According to that defendant who was convicted and that decision was affirmed.
Yes, Your Honor, but like I had said previously, this was a different criminal statute. And it also proves that Congress does, in fact, know how to include a subjective intent standard if they so choose, and they haven't included it in 875C. And the objective test matters because we're attempting to prevent the fear that threats engender, and that is why we have to have this objective standard. Back on my second point of the language that the of the statute, it says you would need to add the language "and intends to the threat to be understood as" for the statute to be understood that I'm sorry. Going back to the definition of a true threat, statements where a speaker means to communicate, you would have to add "and intend to the threat to be understood as" for us to interpret it as our opponents have.
Well, later on in the same paragraph in the Black case, the court says, intimidation in the constitutionally prescribable sense of the word is a type of true threat where a speaker directs the threat to a person with the intent of placing the victim in fear of bodily harm or death. Doesn't that sound an awful lot to you like subjective intent?
No, Honor, no, Your Honor, it does not, because we have to have we have to clarify. Would you mind rereading that language one more time?
It's in the same paragraph as the quote from Watts that you cited, and it says intimidation in the constitutionally prescribable sense of a word. It's on page 8 of the record. Is a type of true threat where a speaker directs a threat to a person or group of persons with the intent of placing the victim in fear of bodily harm or death.
Well, Your Honor, that's why we have to. That's why we have to have the. I see my time is up. May I respond to your question?
Yes.
That's why we have to have the objective standard test in order to determine whether or not that should be interpreted as a true threat or not. We respectfully request that the court affirm the lower court decision because using a subjective intent standard prevents us from convicting someone before there is an injured or dead body. Thank you.
Thank you. Mr. Dettmer, you have 2 minutes for rebuttal.
May it please the court, I would like to address a couple of the arguments that my opposing counsel has made. First, they argue that this court must err on the side of protecting Mrs. Gandil in this case. But in a First Amendment case, the First Amendment always errs on the side of protecting speech unless the speech is part of a narrow class of speech. And in this case, we are very, very close to forms of speech that have historically been protected by this court. Secondly, as Your Honor's pointed out, legal inconsistency is a real concern here because a reasonable person could see this as not a threat, which is the case of some of the people that read these things and posted liking on them or just commenting that I can't believe you got fired for this statement. These things are all possible, and that is why a subjective intent standard is preferred because my opposing counsel stated the jury will still determine under a subjective intent standard, not the person being accused of this. But what it means is that the jury has to search to see if the person could mean what they're saying. Not that they say that they mean it, but that if the jury can reach the conclusion that they did mean it. And you can do this in a multitude of ways. If Mr. Gandil was found stalking her repeatedly, if he had plans to her house, if he had a firearm when he confronted her, those are all things that show action. You know, speech should be brigaded by action if we're going to worry about it, because in the Claiborne case we saw someone who made a statement but was yet still not held liable for that statement because he was not inciting imminent lawless action. And in the case of Mr. Gandil, he was not inciting imminent lawless action. He was posting to Facebook, which many people do when they're angry or upset, and those statements have been misconstrued or could be misconstrued as a threat, and that is the fear. Because if we allow that sort of behavior to occur, if we allow someone's negligence to become malice, we will chill speech. And in order for speech to be free as the founders intended and as the Constitution intends, I see my time is up. May I conclude?
You may briefly conclude.
In order for that speech to flourish, there has to be a very, very loose border around that speech, rather than a strict curtailing of speech. And with that, we respectfully request that this court reverse the lower court's decision.
Thank you. Thank you. We'll take the matter under advisement.
All right.
Be seated.
Thank you. Please be seated. We've decided we'll post our decision on Facebook. See, judges do have a sense of humor. We conferred, and our one charge for today was to determine who the best oralist was, and it was unanimous that Mr. Dettmer wins the prize. So congratulations to you.
Very well done. Very well,
sir.
And we'd like to recognize the other participants as well. Mr. Binder. And Mr. Burnett.
Very well done. Congratulations. Excellent job.
And Mr. Thompson.
Very well done. Good job. Excellent job.
Yes. Fantastic.
Excellent. Excellent. Really good.
I would ask if you would join me in thanking our panel for asking such wonderful questions this evening of our finalists. They would like to make or share regarding the round or the finalists this evening, if you care to share any.
Quickly, I think the congratulations to all of you for wrestling a very difficult problem to the ground and finding the best points that you had, which is what lawyers do. But we can't make the best points that we have and ignore the hard parts of our case. So the very best lawyers not only make their strong points, but they figure out a way to deal with the difficult parts of the case. And so I want to congratulate you for those. Just a few comments that come to mind. Mr. Binder, your response on premeditated murder was an excellent response. We ask juries to infer these things all the time. So that was just something that I wrote in my notes, and I just wanted to compliment you on that. And I won't hog the mic, but I think you all did a really good job. We all have moments of glory like that for each of you. But I know it's a lot of work, and it's scary stuff. And actually, we were nice. So compared to if you ever argue in Chicago, we were really nice. So congratulations for all your hard work. We appreciate it. Dean?
I won't belabor. I agree with everything Judge Stinson said, and I thought one of the things all four of you did very well was going back to the precedent that supports your argument when you have an opportunity to do so. There's a temptation sometimes to go along with the script that you prepare in advance of the argument. So I want to compliment all of you for listening to the questions and returning to the precedent to help support your arguments.
I don't have much to add. I thought, in particular, Mr. Dettmer, your rebuttal was ideal. You get in, you get out, you make your points, you score the points based on what your opposing counsel was saying. So I thought that helped tremendously. For the other three oralists, there were so many terrific points that you all made. The way that you handled the questions and getting back into your arguments. It's a tremendous compliment to all of you and to your professors who helped you prepare for the arguments all through these rounds, because I know some lawyers who would have a tough time arguing against some of you. So congratulations to all of you.
Very good. Another point I wanted to make, another good response, just in my note, Judge Joven asked a question about the victim's interpretation of the threat, and the response was, that's why we have the objective standard. We can't have the victims determining it either. And I thought that was a really good response too. So I just wanted to say that. understand that when you go back to precedent, see, I'm a trial judge, so I don't make up the law. I have to find authority from the higher courts to base my decisions on. So when you're arguing to the United States Supreme Court, they pretty much only care about what they've said, okay? If other circuits have said things, good for them, but we're the bosses here, okay? So when you're at the 7th Circuit in Chicago arguing after you say Judge Magnus-Stinson did a bad job, those people in Chicago could care less what I said. They care what their court has said before. And I care what their court has said before because I have to do what they tell me to do. So that's why when you circle back to precedent, it gives everyone a really high comfort level. And if you can find precedent at the United States Supreme Court, I'm saying this for my high school kids here too because I'm a mom of a high school kid. If you can find United States Supreme Court precedent to help you, it's aces, yep.
Yep, but Mr. Thompson, when I asked you, why are you quoting Locke? The point you made about, well, I needed to help me articulate my point, I thought that was an excellent response.
So we'll see you in court at Judge...
We're even better at law school.
Right. go to Dean Klein's law school, and then I'll swear you in, and we'll see you in about 3-4 years. All right?
So I won't make any comments on the law. If I've learned anything, it's how little of the law I know, but I want to say a special thanks to the 4 young men who've participated in this and for all of those who participated in the preliminary rounds. As I sat here tonight, what I'm going to take away from this is an opportunity to, when I engage with prospective students and their families, and they ask me, well, what does it mean when we say that at Wabash we teach young men to think critically? I will be able to come back to this night and describe this, and for that I'm very grateful to all of you.
Great job.
Great job.